Hello and welcome to Environmental Class Actions, Still Rising or Past Their Peak, a webinar from CDR, Commercial Dispute Resolution. My name's Andrew Mizner, I'm the editor of CDR, and it's my pleasure to chair today's discussion, which will cover one of the most high-profile areas of law around the world in recent years. From the Mariana Dam case here in the UK to the proliferation of cases about forever chemicals or federal climate change cases in the US, a Greta Thunberg-led claim against the Swedish government, or the case against Rio Tinto in Papua New Guinea, environmental class actions have been a recent phenomenon. Emissions, pollution, contamination, all have been challenged in jurisdictions around the world. Filings have increased, awareness has grown, corporate behaviour has changed, and yet many high-profile cases have ended in defeat. Appeals have dragged the process out, and now some governments, led by the US, are pushing back on this area of law. So where does that leave us? What are the present and future of environmental class actions in the UK, the US, and beyond? To tackle these questions, we have assembled an expert panel of lawyers from both sides of the Atlantic who are going to be speaking for about the next hour on this subject and hopefully answering some of those questions. I'm first joined by Emilie Jones, a commercial litigator and leader of the litigation and regulatory practice development team at Pinsent Masons. Emilie began her career as a barrister at the commercial bar before becoming a legal director at the firm, working with clients and internally to provide knowledge support and develop legal technology initiatives. Then we're joined by Adam Heppinstall, KC of Henderson Chambers. One of Chambers and Partners' top-ranked barristers in his field, Adam has worked on a wide range of public interest matters, including the COVID and Grenfell Tower public inquiries, and acted on environmental damage and emissions claims in the US, Africa, and South America, including some relating to the Dieselgate scandal. And finally, joining us from Washington, D.C. is Deborah Greenspan, co-chair of the Energy, Environment and Mass Torts Practice Group with Blank Robe. Deborah has extensive experience of class actions, mass claims, insurance recovery, and mass tort bankruptcy, and has been regularly appointed by US courts as a special master overseeing settlements and payments on a wide range of matters, including those relating to Vietnam War veterans, the September 11th attacks, and the Flint water crisis. So, an illustrious panel, I hope you will all agree. We should have some time for questions at the end of this session, so if you do want to ask something, please put it in the question box at the bottom of your screen and we'll try and get to them at the end of the session. And if you do wish to refer back to this webinar at a later date, a recording will be made available afterwards. So let's dive straight into some of the issues I trailed at the top of our discussion. And Emilie, I'd like to start with you. Perhaps you could just give us an overview of what are some of the current trends for environmental class actions. Would it be fair to say that they have grown over the past few years, but that maybe successes have been a little bit harder to come by? What's your view?
Thanks, Andrew, and thanks for having me today. I think my sort of summary point here would be that environmental class actions have grown. They remain a major business risk. But there are signs that they are stabilizing in the sense of not growing in that kind of exponential way that we've seen in the past. We've seen an overall upward trajectory across the EU and the UK in the last few years in terms of class actions generally, and in terms of climate change and sustainability litigation. That's definitely become a kind of firm fixture on the dispute resolution landscape. And obviously not all environmental litigation takes the form of class actions. Equally, not all class actions relate to environmental or even wider ESG issues, of course. But the combined effect of that is that, as I say, environmental class actions are a real strategic risk for businesses. And I think there are a few trends within that which are, of concern, of interest to businesses, which are worth picking out. And some of these I know we'll explore a little bit more later on. But the first point to make is that these claims can be very large in terms of pleaded value, large in terms of cost, and can last some considerable time. So a really good example you mentioned in your introduction, Andrew, the Mariana Dam case, in which the English High Court's recently heard a second stage trial. That's one of the largest pieces of litigation, I think, that's ever been dealt with in the English courts. It's brought by a group of over 600,000 claimants seeking, I think, tens of billions of dollars of compensation from a mining company for alleged damage which was caused, they say, when the Mariana Dam in Brazil collapsed back in 2015. So a really big piece of litigation that's ongoing. I think the other point to make is that avoiding this litigation presents some really complex risk management challenges for businesses. So the Mariana case is just one example. There are others of class actions being brought against companies in the UK based on activities of their overseas subsidiaries or business partners and suppliers, which is said to have caused environmental harm in foreign jurisdictions. And the English courts are showing receptiveness to taking jurisdiction and hearing those claims here. And obviously there are real challenges for businesses in terms of how best to manage those kinds of complex multi-jurisdictional corporate groups and supply chains when they're thinking about how to minimize the risks of these types of class actions. And that's just one example of the types of environmental class actions we've seen. Obviously, there are others, things like cases based on alleged nuisance emanating from manufacturing facilities, that type of case. But that parent company liability type of case, as it's often referred to, is really, really topical at the moment. And I think we'll talk a little bit more about that later. And I think the third point to make in terms of why these cases are significant, despite that kind of tailing off of the trajectory of them in terms of volume, is that even when they're not successful, these cases, as we all know, hit the headlines. So they're a reputational risk that businesses need to manage effectively. I've talked quite a lot about the UK there, as well as the UK in Europe, and I know Deborah will talk about the US, but in Europe there are other hotspots, and I would call out in particular the Netherlands, a hotspot for class actions generally, including environmental class actions. We've seen a number of significant cases there, like the Emilie defensive case against Shell, seeking to impose a particular reduction on that company's emissions. That's going to the Supreme Court now. And the similar case also being pursued by Emilie defensive against ING, which is, I think, novel and interesting for those in the financial services sector, in that it turns the focus on a bank in relation to the alleged financing of high emitting companies or projects. So that's another interesting jurisdiction and an interesting trend to watch. So, as I say, these claims remain a real risk for businesses in the UK and the EU. But there are some signs that the trajectory of environmental class actions may be flattening out. And I think we see that both in the overall class actions data. So, for example, in the recent class actions report produced by CMS, European class actions report, they noted that fewer new class actions were filed in 2024 than in the preceding few years. And then we also have the Grantham Research Institute on Climate Change and the Environment's annual report on climate change litigation. And that's shown that the numbers of climate change cases being filed each year has been dropping off, actually since peak in 2021. So that's been dropping off for some years. And, there may be a number of reasons for this. Perhaps some, you mentioned some unsuccessful cases in this area from the claimant perspective. And I think there's perhaps been some consolidation on the claimant side, particularly the kind of activist NGO claimant side, in terms of the type of claims being pursued. Perhaps they've tried some novel approaches and are perhaps now focusing on the strategies that they feel have worked rather better for them. Some other points on the data, I think the data looks at new filings, but these cases tend to go on for many years. So there are still plenty before the courts. And some may be tying up some claimant-signed resource, including litigation funding, which I think we'll talk about funding a little bit more shortly. And of course, the data doesn't reflect cases which are still pre-action, and indeed might be resolved pre-action, so never hit that data. But certainly, I think there are some types of claim which, in the UK at least, we're probably seeing perhaps less than we might have anticipated a few years ago. And I would say things like greenwashing, sort of mass claims relating to greenwashing. We haven't really seen that in the courts in the way that I think some predicted, but perhaps partly because there are some regulators in that space, particularly the ASA, the Advertising Standards Authority, and also the Competition and Markets Authority, which have been particularly active. So that seems to have gone in the UK down a more regulatory route rather than being a feature in the English High Court, for example. So that's a kind of canter through what I think are some of the key trends and how this is going, this area of litigation.
Yeah, thank you for that. And there's a number of issues that, as you said, I think we're going to come back to a bit later on. Adam, following on from that, we've heard a bit about sort of the overall trend, but here in the UK, what mechanisms are being used for these claims, and how well suited are they to these environmental claims?
Well, the main mechanism in the civil courts, in the High Court, is the group action. A lot of those group actions, as Emilie was mentioning, don't actually focus on events, on environmental damage in this jurisdiction. A lot of those group actions focus on environmental damage or events which are outside England and Wales, and that's why, as Emilie mentioned, jurisdiction is often the big issue. So whilst a lot of these will in the future be brought as group actions, the first hurdle or the first challenge for the defendant in the court is jurisdiction, whether the case has a close enough connection to this jurisdiction, whether it should be heard here. So, for example, the dam in the Mariana Dam case is in Brazil. It's not in England and Wales. So that case took quite a lot of time before our High Court judge and the Court of Appeal on the question of jurisdiction. Should it be heard in this country? Equally, the Nigerian pipeline oil pollution cases state an obvious fact. The pollution is in Nigeria, but the case is brought against Shell because of its domicile or joint domicile, as it has been in the past, has been here in England and Wales. Very few of the manufacturers in the Pan-NOx cases are based in England and Wales. Their jurisdiction's based on the domicile of the consumer claimants. So that mechanism of the English group action is in fact being often used to bring what are essentially international mass tort environmental claims before this jurisdiction. And another sort of way of looking at them, apart from their international nature, are the sort of novel legal constructs that are often deployed to bring those claims. And Emilie touched on some of those. The one that's most common is the parent company construct. So the idea that it's the English domiciled parent company that's responsible for the allegations that are actually being made directly against the foreign subsidiary in the whatever in the world the alleged environmental damage took place. And some of those are straying away from the parent company construct and more into investors or shareholders, or even the supply chain model. I'm sure a lot of people are aware of the claim that's brought against Dyson, which was the top purchaser in a supply chain that stretched across to Malaysia. Now, those allegations were of modern slavery within that supply chain. They could easily be allegations of the top purchaser either failing to find out if there's environmental harm being caused in that supply chain, or finding out and then taking no action. So a very similar legal construct could be brought for an environmental claim. To show you how tenuous it can get, there's a set of claims at the moment where relating to a ship that sank in foreign seas, and a Middle Eastern minority shareholder, investor in the company that owned the cargo that is alleged to have contributed to the pollution, is being sued because at the relevant time they happen to be domiciled in London and be on the London Stock Exchange, even though A, as I understand it, they're a minority shareholder, and B, they acquired that shareholding after the ship went down. So you can just see how tenuous some of the legal constructs can be in order to bring these group actions within the jurisdiction. So Yeah, the mechanism is certainly the English group action, but it has to be coupled with often very difficult and novel arguments about jurisdiction, and then even more difficult and novel, if not sometimes tenuous arguments about how the company that happens to be in this jurisdiction is legally linked in liability and causation terms to whatever events or loss and damage occurred abroad.
Thank you. I mean, it's interesting how this area of law makes some very international matters very, very specific to this jurisdiction all of a sudden. But if we've been focusing on this side of the Atlantic thus far, Deborah, let's turn to you and find out the state of play in the US. How much is there currently in the way of environmental class actions in the US? I mean, what's the overall picture like?
Okay, well, let me first of all thank you for having me here. I'm very grateful and enjoy being on this panel. So let me give an overview picture right now of the U.S. And I think to answer the specific question about are these cases sort of going to taper down, or, partly I think the question was related to changes in administration in the U.S. And I think the answer to that is no, they're not going to start disappearing. What we're seeing now is, and have for a bit of time, is that cases are being brought in multiple different jurisdictions in the United States. So we have federal government, we have state governments, and class actions or mass actions or consolidations can be brought in both types of jurisdictions. We're, I think, seeing an increasing emphasis on states and actions brought by states, in states, using state statutes that are somewhat different perhaps than what we currently see on the federal government level. We have actions by cities and then private citizens bringing all kinds of actions against that are all related to environmental issues and environmental contamination. So one of the more prominent mechanisms really relates to, misleading or fraudulent representations. These can be brought in various different ways, brought in connection with consumer fraud statutes or unfair trade practices statutes. They can be very fact specific because the statutory language will differ based on what jurisdiction you're in. So if you're a company obviously operating in multiple states across the United States, you're being subjected to different standards, different regulatory standards, and different kinds of statutory guidelines that can generate or provide the support for either class actions, or I'm going to keep emphasizing there can be other ways to have mass actions brought in the United States. So the specific question is this on the rise, or is this declining? I don't think it's declining. I think it's getting more complicated. And we could talk a little bit later about some of the factors that create impediments and risks, and also what I'm going to call the tug of war between state and federal government in the United States. So that's a quick answer to the initial question. Thank you.
Thank you. And we'll come back to multiple of those issues in a short while. I think there's certainly a lot to unpick, especially when you start to separate state and federal jurisdiction out. Emilie, just to come back to you then, or in fact, Adam, let's come back to you first. Are there particular causes of the claims in the UK at the moment? We've heard a bit about a few specific cases, but are there particular causes of actions that are popular at the moment? And is there some divergence between the number of claims being brought on the basis of regulatory action versus purely private matters? What's the picture in terms of causes of these claims?
I mean, one way of looking at causes of claims is to look at the sort of underlying drivers. I mean, one of those most obviously in this jurisdiction is in fact funding, because to bring a claim like the Mariana Dam requires a lot of funding, and either you're looking at a law firm that has won many cases over the years, has built up a huge war chest of its own that it can use to bring future claims, or you look at law firms that either as a firm has received funding, investment, or is actually receiving funding in respect to specific claims. Lots of different ways of structuring it. But obviously, to take a case on, for that case to go on as long as the Mariana Dam case may well go on, requires a lot of investment, a lot of money that may have to come from a commercial funder. And I think to be fair, all eyes, or many eyes, are on the Mariana Dam case, because it's interesting to see whether a commercial funder, as we understand it is in that case, will stay the course. If there isn't if claimants win and there's an appeal, will it stay the course on all those layers of appeal? If the case is lost, will the funders be good for the adverse costs that may well flow in that event? So a lot of eyes are on the dam for the reasons that Emilie gave. It's one of the biggest pieces of litigation, certainly funded litigation of that nature in this jurisdiction. We've just had, or recently had, the CJC, the Civil Justice Council report in this jurisdiction on the regulation of commercial funding of cases of that nature, which would include environmental class actions. Now, there's lots of different views on whether the reforms that are proposed in that report will in fact increase commercial funding or decrease. The reason for that is because what it proposes essentially is lots of increased regulation, increased red tape, if you like, for funders and those who take funding. But my own personal view is that that may well lead in the long term to an increase in funded cases, because it's going to provide certainty and it's going to answer a lot of questions that can raise concerns and uncertainties about funding. So if we take, for example, damages-based agreements or contingency fees, where you are only remunerated as the claimant's lawyers on the basis of a percentage of the compensation that you recover, those have not been used very often in this jurisdiction because there's a lot of uncertainty about how they actually worked. There's a lot of uncertainty, for example, about whether you could recover costs of a interlocutory interim hearing, for example, where you've not actually won the case overall, and therefore are you entitled to any costs at all? Now, all of those long-standing doubts and issues may well be solved once the CJC's reforms, or if and when the CJC's reforms are enacted. So all of that, plus success for funders in cases like the dam, may well actually increase the level of funding. They may make environmental claims of this size that we're talking about, class actions, more attractive in this jurisdiction, and therefore that would be a huge driver going forward in the number of claims and the nature of the claims which are brought. Whether risk appetites can remain the same all comes down to the level of success for these claims, because you need to show a return, you need to show a level of profit for funders that makes it attractive going forward. So not to make anybody nervous, but all eyes very much are on the Mariana Dam, where I think judgment is expected any week now.
Yeah, that's certainly going to be a pretty seismic result, whichever way it goes, for a number of reasons in this sector, including funding. And you mentioned the CJC report, and obviously we're still waiting to hear, exactly how that ends up being implemented. And then the talking of such reports, the government is also undertaking a review of the opt-out regime overall now. So there certainly feels like there's a lot of potential for flux in the near future, not just in relation to funding. But talking of regulation, then, Emilie, so what's been the impacts of corporate regulation then on these sorts of cases? How has it changed with regards to its impacts on, or rather the avenues that regulation creates for bringing environmental class actions, and is regulation creating or generating new causes of claim?
Yeah, well, I think that's really interesting. I think, and some of what I say, I think, will be a little bit forward-looking rather than what's happening right now. But what is certainly true is that companies are publishing more and more in the way of environmental and wider ESG related data. In some cases, that's due to mandatory requirements. In other cases, it's to do with investor or customer demand. I'm not planning to go into lots of detail on all the mandatory requirements, which obviously vary between companies and jurisdictions, and are another area where there is change, regular change on the horizon. But as a high level point, I think it's fair to say that requirements in the UK and the EU to publish ESG related information are alive and well. In the EU, there is some potential delay to and some potential watering down of the EU requirements, particularly the corporate sustainability reporting directive through the omnibus package that's currently making its way through the European legislative process. But there are still very significant reporting obligations for many large businesses here in the EU, and that gives rise to various litigation risks. For example, if matters aren't disclosed, which arguably should have been disclosed, and I think that's a risk that's exacerbated where there are changing requirements or where there are standards that some find unclear. Equally, if points are overstated in information that's published by businesses, or information is set out that isn't supported by kind of robust and verifiable methodologies or due diligence or data, that's another area of risk, or perhaps isn't explained with appropriate caveats or assumptions. Interestingly, I also think that there's an issue where you've got issues that are revealed as more and more information has to be published by companies. You've got issues that are revealed that it might then be argued should have been disclosed, particularly to investors, earlier. And I mention that because in terms of class actions, where I think we could start to see that result in some more litigation is in securities claims brought by investors. So investors bringing a claim saying, you made a particular statement when I bought my shares or when I held on to my shares in your annual report or those kinds of corporate publications, or you omitted some information concerning environmental or other sustainability issues, and as a result, I've suffered a loss in terms of the value of my stock. And I don't know whether Deborah is going to talk about this, but I know that securities litigation is it's very common in the US. They're not easy claims in the UK, but I think we will start to see that attempted more. And in the English courts at the moment, there's a securities case that's going through. It's not environmental litigation, but it relates to sort of wider ESG issues. So it's a claim by a group of institutional investors against the fashion retailer Boohoo, in which there are failures alleged to disclose issues relating to the payment and working conditions of workers in factories in the retailer's supply chain. And as I say, it's not about environmental claims. It also relates to statements or omissions said to have been made some time ago, so back in around the kind of 2018, 2019, 2020 period. But that case is really seen as something of a litmus test for ESG related securities litigation in the UK. So we've talked about cases that people will be watching, and I think that is one of those cases that people will be watching for a sign of what may be to come in terms of a future trend. The other area of corporate regulation, which I think is relevant here, is changes in the due diligence that companies are required to undertake on their supply chain. So the EU has enacted the Corporate Sustainability Due Diligence Directive, or CS3D, CS3D, some call it, which essentially will require, and this is a very high level summary, but essentially will require all large companies doing business in the EU to carry out certain due diligence on their supply chains to effectively prevent adverse human rights and environmental impacts. Now, the omnibus package that I mentioned earlier may delay and water down some aspects of that directive, but that's still going to increase supplier due diligence obligations on companies that fall within the scope of that that directive. And again, I think that's particularly given the sorts of supply chain issues that we've already touched upon. I think international supply chain issues that we've touched upon, and that's another area where increased regulation could drive increased litigation.
Yeah, I think the supply chain issue is one that's, not just within the class actions world, but more generally has become quite a hot issue in recent years, both with the directive and elsewhere in the world. So talking of regulation, then let's move back to the US. So Deborah, you touched on previously the sort of the division between state and federal legislation, and I think we'll come to federal matters a little bit later on. But at the moment, can you give us a bit more detail on what the picture is in terms of how much or how many of these cases are being generated by state regulatory action, and are there particular areas, particular issues, whether emissions or contamination or something else that are, particularly being targeted by this regulation?
Okay. It's a very complex area. It varies, as you can imagine, by state, of course, in the United States. But there's, I think, some trends and some things to keep an eye out for. So, number one, states are, to the extent that the federal government is rolling back some regulations or declining to take enforcement actions, some states are stepping into that role, into that gap. They have their own regulatory schemes. They have their own statutes that they want to enforce. One area that's pretty interesting, and I think it kind of follows on some of the things that Emilie was just saying, are environmental justice statutes that some states have enacted, meaning don't cite all of the manufacturing facilities in certain kinds of areas where, some areas, some social and economic groups or, other kinds of maybe minority groups are more, some facilities are cited more in those jurisdictions. And so in considering where facilities are placed and how they affect the neighborhoods, these environmental justice statutes are telling companies to look at those issues in considering where these are cited. There are, I think I mentioned earlier, the consumer fraud statutes, their trade practice statutes and the like, which have generated a considerable amount of litigation across the country. They're having varied success, depends on your jurisdiction, but there's a recent set of cases in the District of Columbia that they've had survived motions to dismiss. These are cases, one set of cases against oil companies. The allegations are about misleading consumers about the role of fossil fuels in climate change. So this is a climate change related litigation brought under the Consumer Protection Act. And the district court had found that even aspirational statements could be actionable. In a appellate court case, which is a case against Coca-Cola, the challenge there were statements about sustainability goals and commitments that were allegedly misrepresentations based on statements about how product packaging is made. And the appellate court, again in DC, determined that the claims could be allowed to proceed to discovery. So these cases have focused on state, or in some cases city, statutes that are providing certain kinds of protections, or as I mentioned earlier, the environmental justice type of statutes. And of course, states have other regulatory regimes as well that they can enforce and do enforce. And again, it depends on what state, which makes it very complicated to be in the United States here. So there's private actions, there are state enforcement actions. State attorney general bring actions enforcing their own statutes. So you have, if you don't have federal actions, you can have state actions, and you can be faced with actions in a variety of different states. Some of the private actions, though, I think is following on in the discussion about funding, some certainly are brought by what I would call public interest groups. They may engage the assistance of private law firms on a pro bono basis to bring some of these cases, but a lot of them are really generated by interest groups or coalitions of interest groups. But again, the regulatory structure creates complications. It's varied, and the various state statutes provide an avenue for litigation. So.
Okay, all right. Thank you. Thank you. I mean, I'm sure that you could talk all day about the different approach of the different states. So appreciate a few of those trends, and yeah, we'll come back to some federal level matters maybe in a few minutes. I mean, just on that, are there any issues that are particularly generating those claims for the states? Are there any sort of common areas where states are sort of where there are a number of states perhaps that are pursuing similar issues?
There's a variety of issues that generate actions. I think the sort of very broad concept of climate change or the impact of certain kinds of elements in affecting the environment, it is a generator of cases. Events that have occurred generates action. The wildfires in Southern California earlier this year have generated a number of different types of actions. Of some interest is an action brought as a class action alleging that the fires released toxins into the environment because when buildings burned, it released all of the all the components of the building, which could include asbestos, it could include lead, that creates toxins in the environment. And because it's a fire and because the smoke and the debris from the fire spread over a quite a wide area, the winds carry everything, to a great distance, then that's created environmental harm in a broad area of the United States and maybe beyond that. That's separate and apart from the litigation about just the damage and the injuries that have occurred. It's a separate type of action brought against Southern California Edison, which is the power company in Southern California. And at the same time, the United States government is suing Southern California Edison for negligence in violation of its own consumer protection laws in being negligent in creating or being a part of a cause of this fire. So there is, I guess the message is that a lot of different events cause these actions to be brought. Water contamination is another type of claim that's, across the United States. And then other toxic exposures. And I think somebody touched on PFAS a few minutes, earlier on in this presentation. That's all over the country in the United States. There's a multi-district litigation consolidated in South Carolina that's proceeding forward in a variety of different facets. But there are cases all over the country in various states, trials that have started or are about to start, both dealing with cleanup issues and moving into the personal injury area as well. And the PFAS litigation then spills over into consumer products. And I can stop there and we can get into that in a later phase of this webinar, but that is a big driver of litigation right now.
Sure. Thank you for that. I think there are some interesting, very topical areas there. So I think we're moving into some areas of public awareness and politics, as we've touched on a little bit there. So, I mean, Emilie, coming back to you, the Portland annual class actions report cited increased public awareness for class actions and increased public support for environmental claims. So, is the growth of these cases overall, is this empowering claimants? Is that public support having a tangible impact on, the ability to bring claims? And, what do you make of the public perception of these cases?
Yeah, the Portland Communications report, which, as you say, is an annual class actions report, it's really interesting. And I think some of the data in there present, it's a bit of a mixed bag. So the in that report, there's polling of the public about their awareness of and attitudes to class actions. And as a headline point, that data shows that I think 65% of those polled said, yes, if I had an opportunity to sign up to a class action of any subject matter, then I would do so. And that's an increase on the previous 2 years of figures in that annual report. The percentage figures for support in terms of ESG related class actions tend to vary in that report according to the industry of the potential defendant, which is quite interesting. And the energy sector features most highly. But I think what's interesting is you've got those headline figures, but despite those general assertions of support for class actions, including ESG class actions, it's also clear that the claimant population does have some concerns. And one of the most striking figures in that Portland report for me is that it suggests that 81% of the public believe that class actions mostly make money for funders and lawyers. So I do think there remain questions about circumstances in which, if actually asked to sign up to an environmental action, consumers will be, or potential claimants will be keen to do so. And in reality, that I think, may well depend on the type of claimant and the type of issue, and how impacted a particular claimant is or feels they are. Those things will affect their motivations to get involved in a class action. But I think it's interesting that concern goes back to some of the discussion about funding that's come up, but goes back to that concern that people still have about who is really benefiting from these actions. I think one thing that'd be interesting to watch is how this area develops over time. One of the things that comes out from the data is that awareness of class actions is highest among a younger demographic, and obviously that group will grow and influence over time. It already has significant consumer power, particularly in certain sectors. So I think it will be really interesting to watch how that data changes over time in terms of awareness and keenness to get involved in these types of action.
Thank you. Yeah, I think that it's how you slice that data is always interesting, but as these cases go on, and perhaps if we have a big marquee case, that public awareness will continue to shift. So I mean, that's building on that then, and public awareness and support and politics are obviously tied together. So coming back to the US then, Deborah, we've talked a bit about the state level. So obviously at federal level, at the presidential level, clearly there's been a change in attitudes towards ESG issues overall in the, since the election at the end of last year. But I mean, even prior to that, there'd been some shift in some quarters about how some of these issues are viewed. So what impact are we seeing in terms of the class actions market on environmental class actions? Are we seeing from the way the federal government is now approaching environmental issues? Is it too early to have had an impact actually on class actions, or is there ways in which we can already see changes being felt?
So I think it just shifts where the litigation comes from. And let me just give you an example of, you may have seen there's a lot of news about the federal government cutting funding in different areas. So one interesting issue that's going on right now is that there was considerable funding in the previous federal administration for climate initiatives. That there were grants, there was an amount of money set aside for entities to develop and work on initiatives for cutting, basically global warming or things that would be helpful to the environment, or to promote things that would be helpful to the environment in a very general sense. And all of that funding was cut in the new administration. And so the entities that were to receive funding, of course, have sued the federal government, on, seeking to recoup their funding. And they've also sued Citibank. Citibank was the entity through that had some of the funds, and they refused to release them because of the federal order. So there's a suit against the bank as well. So there's a lot of that kind of litigation going on right now in terms of, ESG types of issues that you mentioned. It's basically put companies, I think, in kind of a difficult position because there are still going to be lawsuits. I think the private bar is not giving up on lawsuits about representations made, information revealed, information provided, omitted. What are the representations about particular products? How is the company behaving? Those kinds of actions, I don't think are disappearing, with the nature of the avenue that's being used, I think will be slightly different. But those generate securities actions, as Emilie mentioned, because if there's an allegation that had an effect on the stock price because the company had failed to do something that generated these litigations, that sort of spills over. But then at the same time, there's litigation kind of, I would say, from the other side saying you shouldn't be instituting these kinds of ESG policies. And so you're going to face that kind of litigation. So I think everybody's, kind of trying to wade through this thicket of different policies and different views. I think really it's creating litigation. I don't think it's diminishing litigation, but it comes from different sectors and it comes from different places and, looks at different kinds of theories. I think somebody mentioned earlier novel theories. There will, I'm certain, be more efforts to develop different approaches and different theories. I don't think it's going to eliminate this type of litigation.
Okay, all right, thank you. I mean, yeah, we're so used to some of the headlines that come out on these issues that it's interesting to hear about just how nuanced that impact can actually be, and yeah, especially across the full spread of different US jurisdictions. But Adam, coming back to you then, and sort of sticking with this regulatory theme, if there is a change in direction in the US, and as we've just heard, the impact of that is maybe to diversify rather than get rid of class actions there. But if we do see a bit of a regulatory divergence, and perhaps we're seeing an increase in it on this side of the Atlantic, could we expect to see more cases arising from regulatory causes here? What might that look like?
I think there is an interesting relationship between state regulation of a particular sector and industry, and then the way in which that sector might be targeted by a class action, for example. Sometimes there's a sort of marketing technique deployed by claimant lawyers who will say, government agencies have not regulated these particular companies hard enough. They've got away with whatever is alleged. For example, I'm sure everybody's seen the adverts that they get in the Dieselgate scandal, for example, and you'll see that some of that marketing is, the companies were allowed to get away with various things, cheating on tests and emissions and so forth, and therefore you should hold them to account. You the claimants should come together in this group action and hold them to account. And I think that is a marketing technique. And it may be, I may be a bit of a skeptic, but there may be also genuine consumer interest in stepping into the shoes of state regulators in order to bring those actions where there seems to be a deficit in regulation. If you take water companies at the moment, there's a sort of interesting thing going on where, the Cunliffe report, the Water Commission is proposing certainly a decrease in the number of regulators, if not a decrease in actual overall regulation. And that's coming at a time when those water companies are, for the first time in their history, seeing group actions being brought against them, which arise out of what would otherwise be regulatory breaches, whether it be overflows or pollution events or whatever. So that's one sector where the level of regulation might be falling, but the level of interest from claimant lawyers to bring group actions is certainly increasing. So I think there is something of a link between the level of regulation and the level of interest. We also are looking to some of our regulators to use for the first time some of their new powers. So regulators like the CMA and certainly some of our environmental regulators, we don't exactly know which ones are going to be allocated the powers, but both the CMA and under the Environment Act have powers to essentially cut across group actions if necessary, and to impose compensation schemes on companies in the event of things happening like greenwashing or a recall of products because of environmental damage. They now have the power to essentially impose a settlement scheme and say, for every product that's recalled, there's got to be a sum of money going the other way to the consumer. And something like that, schemes like that, would very much cut across class actions and group actions as they're currently brought in this country. But we haven't seen those powers yet developed into secondary legislation, and we don't know whether bodies like the CMA are going to get the budget in order to enforce them. Key to that, all of that, I suspect, it is also going to be the adverse cost risk, because you can imagine that it's one thing for a company to be faced with a fine or a sanction. It's another for that sanction to amount to essentially a multi-million-pound settlement with consumers. And it may be that those regulators are worried about their own adverse cost risk if that all goes wrong and they can't make out their case, and they end up with a very large cost bill at the end from these proposed defendants, who will no doubt heavily invest in their corporate defence. I mean, it may well be that the adverse cost risk is still the appetite is stronger, ironically, amongst commercial funders than it is with regulators who hitherto have not been exposed to those sorts of corporate defence adverse cost risks. So there's a lot of interaction going on right now between the level of regulation and the level of class and group action risk.
Yeah, thank you for that. I mean, certainly the water companies one here in the UK is interesting, and with that and a few other bits, you've trailed a few future areas we should be keeping an eye on. So on that theme, Emilie, to come back to you, are there some areas that we should be keeping an eye on for the future of this area? Are there jurisdictions or particular areas of the law or causes that you think are going to be particularly worth keeping an eye on in the next few years? Or as you started off by talking about a flattening of the market, do you think that will continue?
Well, I definitely think there are a few areas, sort of subject matters or areas of law that will be interesting to watch. To pick three, we've talked a little bit about securities litigation, and as I've said, I think potential securities litigation based on information about environmental activities and risks in corporate published material, particularly pursued by institutional investors, is an area to watch. As I said, not easy claims in the UK, but I think particularly depending on what happens in the Boohoo litigation, something that we may see more of, at least attempted. You mentioned in opening, and Deborah's also mentioned the issue of PFAS or forever chemicals. I know that in the US there is a lot of litigation concerning those, and we are starting to see that now in the EU, and indeed I think there's a threatened action in the UK relating to contamination arising out of PFAS. So I think that will be an interesting area in terms of watching whether we see here and in Europe what has happened in the US in terms of litigation on that. Some other areas, I think sort of my third, I would say maybe litigation concerning plastics. Again, I think this is something that in the US has been seen quite a lot. Class actions concerning various plastic issues, particularly involving claims by consumers and investors alleging misleading claims about recyclability. And I think when you look at some of what's being spoken about by the kind of environmental charities and organizations, NGOs, that's an area of focus outside the US as well. it remains to be seen, I think, whether in a jurisdiction like here, where we don't have a general consumer opt-out class actions regime in the way somewhere like the US does, we will see consumer class actions in that space. But again, it's an area where we might see things like potential securities claims. So I think that's an area to watch. So those are 3 types of claim or subject matters to watch. In terms of jurisdictions, obviously, the UK is very active in this area, and you mentioned the review that's taking place of the opt-out regime here. We've mentioned the litigation funding review, and lots, I think, to look at in the UK in terms of developments. The Netherlands, I think, will continue to be a hotspot to watch in this area, and I think Portugal will be interesting to watch. So, another jurisdiction which has quite an active regime, active market in class actions, and there is ongoing class litigation in Portugal against the Portuguese state in connection with its climate change mitigation activities. I think that action is ongoing. So, some activity there that I think will be interesting to watch in terms of that as a jurisdiction. So yes, that's my things that I'll be watching.
Thanks for that. I mean, that encompasses quite a lot, and there's certainly some big issues there to keep an eye on. So Adam, I mentioned a bit sort of earlier on about how some of these cases have been very attention grabbing when they've been brought, but haven't they maybe found it hard to be successful. And we've talked over the last sort of 55 minutes about a number of issues, including areas where it's maybe difficult to actually make the case work. So just to sort of as a final one for you, are there any ways that cases can increase their chances of success? Any ways that claimants and claimant lawyers can actually help to improve their chances of bringing a successful claim on these issues?
So I think one of the big issues that has to be cracked going forward relates to causation. So, I mean, very often, as you say, a headline bad thing happens somewhere in the world, and it's very easy to bring a claim focusing on the sort of sensationalist nature of that explosion or pollution event, whatever it is. And liability may well be easy to establish, breach of some statutory provisions, or easy to establish negligence. The problem often is causation. In the climate change cases that we look to the future, it's causation where the real problem is, because it's quite easy to show that one company's actions or inactions may well be contributing to a global increase in emissions and a global raising of temperatures. But how do I show in my particular part of the world, in my circumstances, that there's a contribution to my personal position? One suggested way forward is the use of a more human rights based approach. We know that the European Court of Human Rights has endorsed climate change as potentially a breach, for example, of Article 8, the right to private life. And we know that in human rights cases, causation is given a much lighter touch. There's often a real risk test rather than a but-for causation test. So that can be one answer. Another answer is spend on scientific experts. Do that early, invest early, make sure you have the necessary scientific and expert backing for whatever your case theory is. And then touching upon another facet of this, for example, the greenwashing cases that Emilie mentioned. One of the problems with those greenwashing cases is, how do you prove the consumer choice was influenced by whatever it is that you're alleging? So if it's some white goods, some sort of kitchen equipment that says that it's green and sustainable, and your cause of action is, well, consumers wouldn't have bought them or were heavily influenced by those green credentials, as opposed to the actual performance of the freezer or the dishwasher or whatever it is. That's really hard to prove, and that is where many greenwashing claims fall down in the consumer space, because it's very difficult to show causation in that sense, in the sort of misrepresentation influence on the consumer sense. Now, some of that can be cured by changing the law, Some of it, again, can be cured by spending money on experts and market research and showing that influence, showing that effect. And as we know, a lot of that sort of work has been done before the Competition Appeal Tribunal in those cases. It's going to be interesting to see whether that economic consumer analysis can be brought to bear in the High Court in these sorts of group actions. And of course, the defense will react in kind, and you get, as you do in the CAT contests of economic and consumer behavior experts in court to see who wins. One case I think to look out for, particularly in that climate change case, is the case in New Zealand, Smith and Frontera, the case that was struck out twice, saved by the Supreme Court. But I think any of us out there who are in the English speaking sort of common law world would look at that case and wonder if the Supreme Court hasn't in fact set up about 101 different ways in which a claim can fail, whether it's remoteness, causation, negligence, nuisance. So that will be one of the first common law jurisdictions to look at how far can our traditional common law causes of action, concepts like causation, concepts of remoteness, be stretched to meet the new challenge that climate change poses, particularly to claimant lawyers.
Great, thank you. And yeah, I think these are some of the things that don't necessarily get thought about when we see the splash headline about the claim being brought, but often which come to bear as the case winds its way through the courts. So just a few minutes left then, and a reminder that if you've got any questions, do drop them in the Q&A box, and we'll take a look before we finish up. So Deborah, just then to come to you one last time for now, and we've heard a lot about some of the specific causes of action in the US at state and federal level, but just on the bigger picture to conclude, maybe, are these cases really the best way of bringing about change? Are they, in light of all the different legal aspects there are here, the different forums and jurisdictions and the role of regulation and all the rest of it, can these cases actually be successful in changing behavior and achieving their goals, do you think?
So I think in some sense, yes. But is it the best way to do it? I don't know that that's, if your goal is to create, let's talk about climate change. If your goal is to create and enforce some more actions that will reduce certain risks, piecemeal litigation may not be the best way to achieve that, but it sort of is used, I think, historically when people perceive, or interest groups perceive, that other entities are not taking action. So that's kind of the interplay. I think we've already talked about that. But I think it does. I'm going to pick up on, I think, Adam's point and Emilie's points about awareness. When you see litigation brought and you see a lot of headline news about it, and you see a lot of action around it, it makes people at least understand that there's an issue that some people perceive out there. It creates some awareness. And I don't think that, I think when you go back to the marketing question, it's sort of flipping around here a little bit, but the misrepresentations in product information or disclosure statements or whatever, and are people really harmed because did they really rely on the statement that this was made out of sustainable materials when they bought this product? But there's a reason why companies are marketing it that way, because they believe it will attract some component of the consumer market to their product, because that's what they care about. So but I think that the litigation front, put aside, are people getting lots of damages? Is that their goal in litigation? It does raise the profile of some issues. And I think that has potentially some effect down the road. It takes a while. And things may or may not happen as a result of that. But I do think it has that effect.
Sure. Okay. Well, thank you for that. Last call for any questions. We haven't heard anything yet, but if you do have something, please do speak now or forever hold your peace while I just say a few more words. So yeah, you've got another sort of 30 seconds to drop your question in. But that aside, we've covered a lot of issues here today, and I think we could have spoken probably for a whole day about this subject. There's so much to cover, and some of these cases just on their own are so big, and we'll be having to keep a close eye on some of those developments in the coming weeks, months, depending perhaps on when we get the Mariana Dam ruling and next few years. I hope the last hour or so has given everyone a taste of some of those issues at play, though, and where this side of the legal market might go. If you wish to relive this webinar, the recording will be made available in the next day or so on the CDR website. If you're interested in more discussion, we do have a question. So yeah, just I don't know if anyone wants to pick this up, but let's take this one. What should businesses be doing now to prepare for these threats? Does anyone want to pick that up quickly?
Well, I think businesses should be reviewing their all of their statements, their disclosure statements, their advertising statements, their the labels on their products, and with an eye towards the types of litigation that has been brought to determine whether they have areas that they should take a closer look at. I think that's one. I think they probably ought to be looking at their insurance, asset, basically. What kind of insurance do they have, and should it be, should there be something different, some other kinds of policies put into place to consider these kinds of potential events, and also looking at, I think Emilie may have touched on this earlier, supply chain. Where are you getting all of your products or the components that you use or incorporate into products? Are there issues there? It's really just a very, what I would just say is a scrutiny of your current practices and see whether there are any areas based on what you're seeing out there that could be altered a bit to help guard against some of these claims.
Yeah, that makes sense. Thank you. And if those of you who are attending and watching us today, if you're interested in more discussion about the current state of class actions in the UK, in Europe, in the US, and perhaps further afield, then if you haven't already, please take a look at the Global Class Action Symposium, which will be taking place here in London in November. In-person and virtual tickets are available now. So, wherever you are in the world, if you're interested, you should be able to sign up. Visit global-classactions.com or visit the CDR website and click the conferences tab, and you should see details there. But we will be talking a lot more about some of these issues in November. So thank you to everyone who's been paying attention to us today and who's joined us for this session. For regular news and analysis of the class actions market, as well as commercial litigation, arbitration, and business crime issues, please visit the CDR website, cdr-news.com. And if you're interested in discussing these or any related issues in greater detail, please do feel free to get in touch with me or the CDR team. But for today, thank you to Emilie, to Adam, and to Deborah for your time and insights. And thank you to the audience for joining us today. And I hope you enjoy the rest of your day, whichever side of the Atlantic you're on, whether it's morning or afternoon. Have a good day, everyone, and thank you very much. Goodbye.